Hello everyone, welcome to USA State. Today we are breaking down one of the biggest legal battles in modern American history, President Trump's executive order to end birthright citizenship and the Supreme Court ruling that just brought this fight to a dramatic conclusion. For more than a year, millions of families have been watching this case with a mix of fear, confusion, and hope. The core question was simple but explosive. Does a child born on American soil to parents who are undocumented or here temporarily automatically become a United States citizen? The Trump administration said no. The Constitution, according to most legal scholars, has always said yes. If you are interested in this topic and liking this video, please stay tuned until end of the video, because we are going to walk through exactly what happened, who this affects, and what it means for your immigration journey going forward. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now, let's get into the video. Let's take a closer look at where this all began. On January 20th, 2025, on his very first day back in office, President Trump signed Executive Order 14160, titled Protecting the Meaning and Value of American Citizenship. In a recent development that shook the legal world, this order directed federal agencies to stop recognizing automatic citizenship for babies born in the United States if their parents were in the country illegally, or if their parents were present only temporarily, for example, on a student visa or a work visa. According to the order itself, the administration argued that these children were not, in its words, subject to the jurisdiction of the United States, a specific phrase pulled directly from the 14th Amendment. Officials argue that the amendment was never meant to grant citizenship universally to everyone born on American soil, regardless of their parents' immigration status. However, before jumping to conclusions, it's important to understand just how radical this interpretation was. For more than 125 years, the settled understanding of the 14th Amendment has been rooted in a principle called jus soli, meaning citizenship by place of birth. This principle was firmly established in 1898 in a Supreme Court case involving a man named Wong Kim Ark, who was born in San Francisco to Chinese immigrant parents. That case has stood as the legal backbone of birthright citizenship ever since. So, when the new executive order attempted to reverse this, it immediately triggered a wave of lawsuits from civil rights groups, state attorneys general, and affected families across the country. Reports suggest that within days of the order being signed, federal judges in multiple states issued injunctions blocking it from taking effect. What makes this case different from typical immigration disputes is that every single lower court that reviewed the order concluded it was unconstitutional. One judge went so far as to call it, quote, blatantly unconstitutional. On July 24, 2025, the Ninth Circuit Court of Appeals reaffirmed that the order violated the citizenship clause. Despite these repeated losses, the administration pushed forward, and in September of 2025, the Justice Department formally asked the Supreme Court to review the case, setting up what would become a defining constitutional showdown. So who exactly was affected while this legal battle played out? The following categories were under review throughout this process: children born to parents who entered the country without legal authorization, children born to parents on temporary visas, including certain student and work visa holders, families relying on categories like the CR1 and IR1 spousal visas, where a child might be born in the United States before a parent's status is fully resolved. And, indirectly, this created ripple effects for green card applicants, deferred action for childhood arrivals recipients, and even hospitals and state agencies unsure how to issue birth certificates during the period of legal uncertainty. As a parent or expecting parent caught in this situation, this uncertainty likely felt overwhelming, not knowing whether your own child's citizenship status could hinge on a single court ruling. To put this in perspective, imagine a family here on an H-1B work visa, expecting their first child in the United States. For over a year, that family had no clear answer about whether their newborn would receive a social security number, a passport, or basic legal recognition as an American. Hospitals in several states reported confusion among administrative staff about how to properly file birth certificates while the injunctions were in place. Immigration attorneys were fielding hundreds of calls a week from anxious parents asking the same question, "Will my baby be a citizen?" This is the human side of a legal fight that, on paper, looks like it's just about constitutional interpretation. On December 5, 2025, the Supreme Court agreed to hear the case, which came to be known as Trump versus Barbara. Legal analysts suggest that this was one of the most closely watched oral arguments in years, and the justices heard the case on April 1, 2026. Advocacy groups including the American Civil Liberties Union, the Legal Defense Fund, and the Asian Law Caucus represented families challenging the order, arguing it violated not just the Constitution, but also a federal statute, the Immigration and Nationality Act, which incorporates the same jurisdictional language. Now, here's what you need to know. The real question is how the court would rule, and on June 30, 2026, the Supreme Court delivered its answer. In a 6-3 decision written by Chief Justice John Roberts, the court struck down Executive Order 14160 as unconstitutional. The ruling firmly reaffirmed that children born in the United States, regardless of their parents' immigration status, are citizens at birth under the 14th Amendment. In the opinion, the court traced this principle all the way back through American history, emphasizing that the framers of the amendment intended to extend that promise to what the ruling described as every freeborn person in this land. What this translates to in practical terms is significant. The executive order is permanently blocked and cannot be implemented anywhere in the country. Birthright citizenship remains exactly as it has always been understood. If you are born on United States soil, you are a United States citizen, no matter your parents' status. Immigration experts note that because this ruling came directly from the Supreme Court, there is no further appeal available to the administration. This is now the final word on the matter, at least through the judicial branch. Beyond birthright citizenship itself, the administration has continued pursuing other aggressive immigration enforcement priorities, and it remains to be seen how this defeat might shape future executive actions. Legal analysts suggest that this ruling could also serve as a broader signal to the administration about the limits of executive power when it comes to constitutional rights that Congress has codified into statute. In practical terms, what does this mean for you if you are currently navigating the immigration system? If you have a pending green card application, whether through adjustment of status or consular processing, this ruling removes one major source of uncertainty for your family. If you are on a temporary visa such as an H-1B or an F-1 student visa and expecting a child in the United States, that child's citizenship is secure under this decision. Processing times for related paperwork, such as passport applications and social security numbers for newborns, should return to standard timelines now that the legal cloud has lifted. Despite this victory for birthright citizenship supporters, many fear that immigration enforcement in other areas, including Immigration and Customs Enforcement, ICE, Operations and Customs and Border Protection, CBP, procedures, will continue to intensify. So while this specific fight is resolved, the broader landscape of American immigration policy remains active and evolving. To put this in perspective one more time, this ruling did not change any other part of the immigration system. It did not touch H-1B lottery rules, it did not change green card backlogs for categories like EB-2 or EB-3, and it did not alter the requirements for forms like the I-130 or the I-485. What it did was settle once and for all through the highest court in the land that the 14th Amendment means exactly what it has meant for well over a century. Immigration experts note that families should still stay alert because while this particular executive order is dead, the administration has shown a consistent pattern of testing the limits of executive authority on immigration matters, and future policy changes could still affect visa categories, enforcement priorities, and processing procedures in other ways. For those of you currently in the middle of a green card process, whether through consular processing at a U.S. embassy abroad or adjustment of status here in the country, this ruling offers a moment of clarity in an otherwise unpredictable environment. In practical terms, that clarity means one less variable to worry about as you plan your family's future in the United States. That's all we have for this bulletin. The Immigration Update channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, please subscribe to the channel for more U.S. immigration update videos.